A very good afternoon to all gathered here. On behalf of Justice Tushar Rao Gadela, who actually initiated this, it wasn't me, correction here. And on my behalf, it is indeed a privilege to extend a warm welcome to each one of you present here for this symposium, Pleading with Precision, Decoding Order 6 CPC in the Context of IPD. Justice Devendra Kumar Upadhyay ji, Chief Justice of Delhi High Court, sir, your constant guidance and encouragement continues to inspire initiatives aimed at strengthening the justice delivery system. Your presence today adds special value to the symposium, and I'm sanguine that your words of wisdom will enrich all of us on the importance of pleadings, and there will be many takeaway points for us. I welcome Justice Avnish Jingan, Judge in charge of the original side, whose guidance on the original side and meaningful discourse and discussions each day we have helps us in resolving several issues on procedures, filings, etc. One line for Justice Tushar Rao Gadela, who has actually conceived this whole idea. And subject to correction, since I'm midst of so many specialists in IP law, there is no copyright in ideas, but Justice Tushar Rao, we will give you protection in this copyright today. Welcome to all my colleague judges who've spared their time amidst all the busy schedules that you have today. This really means a lot to us. I will fail in my duty if I don't separately acknowledge the presence of Justice Pratibha Singh here, the persona behind the IPD. I may dare say the personality rights are yours completely. I congratulate the committee, which is instrumental in drafting the IPD rules, which are of a great assistance to all of us. So many congratulations and thanks to Justice Pratibha, Justice Naveen Chawla, and Justice Sanjeev Narula in absentia, of course. I may extend my warm welcome to Mr. Hariharan, the President of the Delhi High Court Bar Association, Ms. Premlata Kajal Chandra, for being here. Your support has been unparalleled in many ways. Thank you for being here. We extend our heartfelt gratitude to Mr. Praveen Anand, Mr. Sandeep Sethi, Mr. Chandar M. Lal, Mr. Jayant Mehta, Mr. Jay Sai Deepak, Ms. Swati Sukumar, senior advocates, Mr. Sai Krishna Rajgopal, who have graciously agreed to impart their learnings from the deep reservoirs of their long and rich experiences, insight, vision, and wisdom in IP litigation, and on how the pleadings really have to be drawn. We also welcome Mr. Arun Bharadwaj, Registrar General, Ms. Kaveri Baveja, the Registrar Vigilance, and Mr. H.K. Arora, Registrar of the original side. I welcome all other senior advocates and lawyers who have gathered here today. Your enthusiastic participation today on a Saturday is a testament to the seriousness with which the IP Bar continues to engage consistently towards development of law by various forums such as conferences and symposiums of this kind. This IP Bar, I know, boasts of several professional and fabulous senior lawyers and other lawyers. IPR is a niche area, and a robust and a strong IPR regime is necessary for our growing economy. May I take this occasion, though it may be slightly out of context, to put on record that IPD was created in 2022, and between February 22 and June of 24, 80.8% patent appeals, 83 trademark appeals, 83%, and 76.2% patent revocation matters have been disposed of. Of the 2002 cases which were transferred from the IPAB, 1,530 stand disposed of. And this is kudos, thanks to the IP Bar, which comprises of senior counsel and counsels who are highly specialized, dedicated, and render meaningful assistance in court, without which none of us can function. Creation of IPD, shortening of procedures, strict timelines under the Commercial Courts Act, framing of IPD rules to streamline case management, consolidation of cases. All of this with a singular objective: expeditious and effective disposal of cases. But at the heart of all this lies one essential element: pleadings. And hence, according to us, a symposium of this nature has been long overdue. The craft of pleading is a discipline, one that demands constant learning and practice in drafting. But the point is, do we ever pick up those big volumes on law of pleadings or CPC? The answer is no. This symposium is an active investment in that discipline, and I commend and thank all those who have chosen to participate in it today. Pleadings are the foundation upon which every case is built, as it is your plaint which outlines the scope of the dispute, crystallizes the issues involved, and pleadings which are crisp, concise, focused, and complete in disclosure facilitate effective and expeditious disposal of cases, which is especially important for an IP litigation where even a grant or a non-grant of a temporary injunction can break or make a business. Disputes in IPD involve patents, trademarks, copyrights, and designs, which are inherently technical and commercially sensitive. Because of this specialized bar, we are uniquely positioned to elevate the art of drafting to match the high stakes of the rights involved. While we have eminent speakers today to enlighten us on pleadings, but I may only say this as a prelude, that plaints should neither be long or verbose, nor theatrical or prolific, but precise. Each ingredient of the statutory provision being invoked must be pleaded, not assumed. The facts that give rise to the cause of action must be stated specifically, not buried in annexures or hinted in general terms. And everything that is material to the court's decision, including and especially that which may be unfavorable, must also be disclosed truthfully and in full. The common problems, I'll take about a few seconds to share, and this is out of my personal experience. So you have infringement suits sometimes where even the impugned goods or services are missing in the plaint. You have passing of suits, but the comparison of trade dresses, packaging is as scarce as it can get. Similarities are compared, but are not in the manner that they should actually come out in a pleading. And courts are left to hunt and hazard guesses from the thousands of documents that are appended to fill in those blanks. For takedown directions, prayers are sweeping, urgency is grave, and yet the URLs are nowhere to be found in the plaint. Court may be very sympathetically inclined to grant a relief to the plaintiff on merits, but finds itself at crossroads, unable to grant any order because the URLs, as basic as that, are not mentioned. And then sheets and sheets of lists of URLs handed over. Well, we may take it, but the question is, would there be a compliance of Order 39, Rule 3? The answer is no. In copyright litigation, the problem sometimes assumes a different character. Plaintiff sues for infringement, but does not identify with clarity the precise work in which it seeks copyright. Sometimes the pleadings lack clarity on what is the work, whether it's literary, musical, dramatic, and in this whole saga of sparse pleadings, the court is left without any tools which it needs to adjudicate and grant relief. Another subset is suppression and non-disclosure. Earlier litigation, prosecution, history, defendant's true launch in the market. The result, that when this is discovered, either the injunction is not granted, or if granted, is instantly vacated. This is a situation that a candid plaint can certainly prevent. Likewise, properly drafted paragraphs of cause of action, territorial jurisdiction, can avoid multiple applications that we are all the time lost in. Order 7, Rule 10, Rule 11, Order 6, Rule 17, which take up years and years of judicial time, and trials are prolonged. Therefore, everybody here, I can only say consequences of inadequate, insufficient, or vague pleadings are far too grave than we can imagine. And therefore, we gather here today to engage in the best tradition of the collegial relationship between the bench and the bar that has always been the strength of this institution. The insights of the speakers that we have today, as you can see on the dais, will be of immeasurable value. And I have no doubt that all of us on the bench, no less than at the bar, will leave this auditorium more enriched than when we entered it. If today's discussion helps us move even a little closer to greater clarity, discipline, and precision in pleadings, the symposium will have served its purpose. With those words, I thank you, all of you, to be here, and we look forward to a great discussion ahead. Thank you.